Cook, Barquette, Ponder, and Wolz are very proud of the results they obtain for their clients, but you should know that past results afford no guarantee of future results, that every case is different and must be judged on its own merits, and that the choice of a lawyer is an important decision and should not be based solely on advertisements. And now, back to Tell Me I Have a Case with Dan Grimm and Matt Glenn.
And we're back for segment 2 of Tell Me I Have a Case, the show where we invite you to take a second look at the world of personal injury law. Today we're talking about how workers' comp claims can lead to third-party claims, and Dan and I are joined by our partner Phil Barquette, who's been with Cook, Barquette, Ponder, and Wolz since January 1 of 2003. He's been practicing law in Southeast Missouri since 1975, 47 years worth of legal experience. Got a lot of stories where we've had to narrow it down. But one of your cases I found really instructive. It took place at an industrial plant where they had railway cars. What happened in that case?
The industrial plant in that case was using rail cars to receive product from outside the plant that it then used in the manufacturing process. They dumped the product from the rail cars into bins that was then transferred to another part of the plant. The product would come in by rail, usually 2 to 3 rail cars a day, and those rail cars had to be emptied. That process required the cars to be moved from one location to another. As one car was emptied of product, they had to move the 3 cars down one so the second one could be emptied.
And they'd have to move them after the locomotive that had dropped them off there had already left.
Oh, yeah, the locomotive was long gone from the scene, and there was nothing really to move those fully loaded cars with, except...
What'd they use?
Well, yeah, they developed a process of using a rope with a hook and a winch to pull 3 loaded rail cars down the track to be unloaded. One time, on this occasion, the hook attached to the rail car came loose, and of course, being taut, that is tight, it flew back and hit the operator, or one near the operator, a person near the operator, in the head.
And that caused him injury?
Oh, he had a serious brain injury.
Yeah,
he did.
And that was one that altered his life significantly.
Unfortunately, yes.
Yeah, and so now moving rail cars that weigh several tons with a rope, a hook, and a winch. Is that the way that most in the industry do that safely?
No, that's not the way it's done safely. And how most of them do it, frankly, Matt, I couldn't tell you. But in this particular case, that's how it was done.
Yeah. And when you get a case like that, did it come in as a workers' comp claim, or did that one?
It initially was a workers' compensation claim.
Mm-hmm. And so you, at your investigative process, then you would need to be looking to see what other potential causes there could have been, or negligence there could be that caused that injury. What were you able to find?
Well, we were able to determine that, number one, this process they had for moving rail cars was wholly insufficient. It just didn't work well at all. And there wasn't enough guarding for the operator of the winch to prevent injury if something like this happened. You could anticipate that the hook would possibly break loose and come flying back towards the winch operator, and that's what it did in this case.
Well, yeah, after several years or months of this product being used to move several tons, I mean, that causes stress on a hook like that.
Absolutely.
And eventually it's going to fail.
How quickly were you able to get involved in the case after the injury?
We were involved pretty quickly, and that was important because we were able to get on the premises and see how everything worked and what the process really was.
What's the better way of moving those rail cars?
They actually make a small locomotive, industrial locomotive that operates around plants, just on the plant premises, and that's what that should have been used in this case. Not a full-size locomotive, but a smaller one, just used to move 2 or 3 cars at a time.
Yeah, and that's, I would imagine that's a little bit more expensive for the factory operator.
Certainly it's more expensive than a rope and a winch, yes.
Yeah, but it's safer.
Much safer.
Yeah, and that's what you see in a lot of products cases where we have to allege as attorneys that there's a safer way of doing this, that there is something they could have done that could prevent this injury, and then it's up to the company to take the action they need to do. And yeah, they might lose a little bit more money, or it might cost them a little bit more on the front end, but they're keeping their workers and their customers and the public at large safe.
That's what we're trying to do. Matt, I've noticed over the years, actually, that products liability law has gone a long way to make products safer. Companies sit up and take notice and redesign their products, and it's been helpful for everyone.
Yeah. Well, I mean, how much safer do you think cars are now versus 1975?
That's a very good example.
Yeah. I mean, every car now, people are far more likely to survive a crash or not get injured in a crash because if they make a defective product and injure somebody, there's somebody like you who will come along and hold them accountable.
What we've really seen, say in the area of farm equipment, we've really seen great improvement in the safety of farm equipment over the years.
How so?
They make modifications that have been suggested by lawyers in products liability cases, and they use those as a baseline to go out and redesign a safer product.
Yeah, yeah. I mean, it's a tough way to make them change because you wind up with a client who's injured. But I've had clients say to me, and I know they've said it to you, that a lot of times one of the things they'll say in that first meeting is, I don't want anyone else to have to go through this. And one of the things you can tell them is, we're going to put them on notice of this particular injury, of this defect in their product, and we're going to show them how there's a better way to do this. And yeah, that you may have gotten injured, but maybe you're going to be the last one. I had a client once who her father was killed when a car struck his mechanized wheelchair. And this is a wheelchair that was built to go out on the roads, but it didn't have any reflective tape on it at all. And at night, you couldn't see him. And so we brought that case. We did the best we could with it. We got some recovery on it. But I told her, I said, look at mechanized wheelchairs, 2 years from now and see if you start to notice anything. And we both have. We've started to notice they're putting lights on the side of them. They're putting reflective tape on the back of them. And it's that sort of thing that, it really, you can make a positive change in the world.
That's what we try to do with every case that comes in the office, make a positive change.
Yeah.
And the idea is to make your community safer, and that's part of what we do as attorneys, is these changes make our community safer for our families, our community, and their children.
Yeah. If there's one area of injury that I think you've had a lot of cases in, you seem to attract a lot of cases where the client has been electrocuted.
Electrocutions are horrible cases and require early investigation to find out the nature of the line and what's going on. But we've had some success with pursuing electrocutions caused by over the landscape electrical lines, the big lines that are moving lots of current. And we've been successful in several of those.
Are those cases where those lines have come down for some reason?
No, they're cases really where the design is improper. There's a booklet called the National Electrical Safety Code that prescribes how much distance a line should be from a particular building in certain situations. And so we look for violations of the Natural Safety Code. But very few. I think I've had one case where the line actually came down and had a loose end that electrocuted someone. But usually the initial design is what we're looking into.
When you have one case in particular that was local here, it involved a painter, I believe, at a facility. What happened in that case?
That was a case in which the line was improperly placed when it was originally constructed. And the painter was using a man lift to help him paint the side of the building. He had to get up to the height of the top of the building to paint the side. And he came too close to the wire, was electrocuted, but the wire was in the wrong location.
And who would put it there?
The original installer, the construction company that originally put it in.
Was that an out-of-state company?
That was an out-of-state company.
Yeah.
Did this case start off as a workers' compensation case, or
It was. It started as a workers' compensation case. I urge everybody out there, as well as other lawyers, to look at all their workers' comp cases and to determine and see whether they've got a third-party claim embedded inside that workers' compensation case.
And if they don't know whether they do,
They can call us.
573-335-6651, you can ask for Phil. He's an expert at evaluating these. Yeah, because that's the type of case with with an electrocution. What is that person looking at in terms of benefits and comp?
Well, in this case, it was a death case, unfortunately, and that pays a stipend, a monthly check to the widow for the rest of her life.
Yeah,
but no more.
and
that's it.
That stipend's not. That doesn't even equal what that person was making per month, does
No,
it?
it's a certain percentage of what they were making.
Yeah, and so they're not receiving. Not only have they lost their spouse, but they're not receiving even the same paycheck that they were receiving before.
And I might add that workers' comp has a maximum that it will pay, and as wages have gone up around here, that maximum is often exceeded.
is that the importance of a civil case? To where a civil case, you can make those adjustments that you cannot make in a work comp case.
That's true. In a civil case, you can go after the full loss of wages, which you can't always do in a workers' comp case.
As well as non-economic damages.
Yes, those are also included.
The non-economic damage would include loss, a consortium, pain, suffering, loss of the family.
Loss of a spouse, that's a very huge element.
Right.
No. So we've been talking with Phil Barquette, who's been practicing law in Southeast Missouri since 1975. He went to Harvard Law School, has a degree in physics from the University of Notre Dame. Dan and I are feeling woefully uneducated during these segments, but certainly also, as is inevitable when you're talking with somebody who's been doing this as long as Phil, we lack the same experience you have. I know I've noticed in my 22 years of doing this a lot of changes in the law in the state of Missouri. What have you noticed in terms of that trend during your career?
Well, we've had a lot of new laws enacted by the legislature from time to time. Most of them are seem to be meant to put roadblocks in front of plaintiffs and recovery. But I've also found that over the years, plaintiffs' lawyers can be pretty inventive, and we try to do the best we can with the law as it is, and we do a good job of that.
Yeah, the good ones find a way. But in each of the cases you've talked about today, I think you had some traumatic brain injury cases. That's a type of injury that alters everything that you do for the rest of your life. You had an electrocution case that ended your life. Putting roadblocks in between somebody who was injured at the negligence of another company who took a shortcut, that strikes me as something that it's got to at least stick in your craw a little bit.
It does, and it helps motivate you to do everything you can for your client, and I think we're motivated.
Yeah, I agree. Ultimately, at the end of the day, if we do take a case and it doesn't settle, who gets to decide what the case is worth?
Then we'll submit it in a trial to a jury, and they will decide.
And that's 12 people, just like the people who are listening to our program right now.
Yes, that's our audience.
Right. Those are the folks that come in, and it's really, I like to look at it. It's kind of like the free market at work. It's almost a capitalistic way of doing this. We're going to grab 12 people that none of us know, none of us will ever see again. We're going to put them in a box, tell them our story. Defense will tell their story, and they come out and tell us what the case is worth.
That's the process we'll have to go through if we can't resolve it beforehand.
Well, and there are very few who've done it better since 1975 in Southeast Missouri.
We've had a lot of good experiences.
Yeah. It's been an honor to practice with you the last 6 years. I look forward to another 10 or 15 years practicing with you.
I hope you're right.
And so we want to thank Phil Barquette for joining us today on Tell Me I Have a Case. We've been talking about turning workers' compensation claims into third-party civil claims. No one in Southeast Missouri does it better, and no one has more experience in doing it than Phil Barquette. You can reach him at 573-335-6651 or at www.cbpw-law.com. cookbarket.com. For Dan Grimm, I'm Matt Glenn. Apologies to Mike Ponder. We ran out of time. We'll try to get to him next week. Thanks again for listening to Tell Me I Have a Case.
Thank you, Phil.
You've been listening to
awesome.
Tell Me I Have a Case with Dan Grimm and Matt Glenn. If you have questions and need answers, contact Cook, Barquette, Ponder, and Wolz today. Just go to cbpw-law.com. See you next week for Tell Me I Have a Case. The choice of a lawyer is an important decision and shouldn't be based solely on advertisements.